This conference will now be recorded.
Pursuant to Executive Order Number 20-69 by the Office of Governor Ron, March 20th, 2020, this meeting, governing board without having a quorum present physically or in any location utilizing telephone or video conference by section dot 4.5 Florida statute. The public comment brings as shortly. Member of the Board of Adjustment hearing. Vote for this meeting, Vice Chair Cody.
The agenda, the materials for each item on the agenda, and a notice regarding the virtual meeting were made available beginning October 9, 2020 on the town's website and is available in the town clerk's office during business hours. The public was given the opportunity to submit public comments to the town clerk prior to the meeting. The town has developed several new methods in sharing public comments for a virtual meeting. Any person may be heard by the Board of Adjustment through teleconference and upon registering with the town clerk pursuant to the published notice to speak for not more than 3 minutes on any item on the agenda. Since it's a virtual meeting as authorized by the Governor of the State of Florida, members of the public wishing to address the body may do so by the town clerk will unmute the public once the chair calls for public comment. Persons interested in speaking may speak up to voice their public comment. Do not unmute your physical phone until you're ready to make a comment. Remute your phone once you have completed your public comment. Persons who cannot access the meeting by teleconferencing using a computer with speaking capabilities or through a smart application can call Town Hall at 561-732-2635 and notify a Town Hall staff of their public comment. The Town Hall staff will notify the town clerk who shall read the public comment into the record. These public comment options established for the virtual Board of Adjustment meeting comply with Section 286.0414 and Section 120.54 Florida statute. The public that is physically present on the Board of Adjustment meeting may participate in public comment by coming up to the podium. Town of Ocean Ridge has a facial covering requirement and also encourages the public to practice social distancing. Chairs within Town Hall have been measured to comply with the 6 feet social distance requirement. No touch hand stations have been placed next to the podium as well as next to the entrance doors of Town Hall. Tips for a virtual meeting. Try to use one device. Do not attend the meeting by using both the computer and the telephone at the same time, as you will experience feedback with a strong echo and will not be able to hear the participants of the meeting properly. Mute your phone. If you are attending by teleconference or computer, those that do not mute their phones can cause disruption into the meeting. Do not unmute yourself. If you are attending by GoToMeeting application or a computer, please do not unmute yourself. The town clerk will unmute persons after public comment is called by the chair. If you have physically muted your phone, please unmute only after public comment is called for and town clerk has alerted the public to unmute. After you have made your public comment, make sure to mute your phone. The information in the chat box is a public record. All Town Hall is experiencing technical difficulties. Chair Sloat?
Here.
Vice Chair Cody?
Present.
Member Bingham? Member Hinton?
Present.
Member Joel?
We'll have copies. I'll second that. All in favor?
Aye.
Proceed now call order the agenda item number 4.
An application application submitted by Waterfront ICW Properties LLC as owner for parcel of property located in Ocean Ridge, Florida, 33435, to the parcel control number of 46, 43, 45, 22, 00005020, requesting for an appeal from an administrative decision official citing the following provisions of the Land Development Code. A, Article 1, Section 1-3, definitions of accessory structures. B, Chapter 64, zoning, Article 3, district regulations, Section 64-1, RSF and RSC, single-family residential districts, subsection B, permitted uses. C, Chapter 64, zoning, Article 3, supplemental regulations, Section 64-41, accessory uses, building and structures generally, subsection B, development regulations, paragraph 1, location. The applicant is asserting that they should be allowed to obtain a permit to construct a seawall without first constructing or obtaining approval to construct a primary structure. The property parcel control number is 46, 43, 45, 22, 00005020, and legally described as 22-45-43 north 300 feet of south 1220.17 ST of POV lot 5 LYDW of and adjacent to CL of Spanish Creek in OR 29270P36. All fees have been paid, and I've only received one additional correspondence. Chair and Board of Commissioners, my name is Patty Rogers. I am representing Ocean Cape Condominiums Association, 6550 North Ocean Boulevard, Ocean Ridge, as president of the association. My intent is of the 12 unit owners of Ocean Cape is to inform the Board of Adjustment and any and all parties interested that we vehemently oppose not only the appeal relating to the specified provisions, but we vehemently oppose any changes made to said parcel number ending in 0020. While this is here to address the appeal, let it be remembered the facts, figures, and data previously presented which led to the denied application still exist. Constructing a seawall resulting in the irreversible destruction of the stabilized habitat bears no logic at this time. In addition, to construct a barrier around the perimeter of any area would lead one to assume that the area will soon be altered. At this time, that intent has yet to be validated. This is definitely putting the for the board. Thank you for allowing me the opportunity to present our views. Again, Patty Rogers, President of Ocean Cape.
At this time, ex parte communication. Well, identify subject. Statement on this be provided to for public record. Issue. Council of the Board of Adjustment may identify existence of any investigation, site visit, expert opinion, conflict. I went to visit the site after receiving the packet. I also want to state that I serve as the Vice President of the former Mile Beach Club. Thus, am on the board of this organization. Familiar with the names of and his LLC Waterfront Properties. He has a different issue ongoing with the organization. I do not believe this for a reason. I live in Ocean Cave, the property Roger president of. I have gone out the area, but I have not done investigation. We will proceed with hearing on this matter.
Hold on, Mr. Chair. I apologize. Last night I received a email from the applicant requesting a I wanted to ask on the record if they were still interested.
Morning, my name is Matthew Scott. I'm here on behalf of the applicant. Yes, we fortunately are unsure what the standards of review are for the application. Place forth that relate to sort of analysis you conduct about probable cause. However, the code is silent on what the standards of review are, whether it's client gets a de novo review, or whether you're looking to see if there was clear error by the building official. And town attorney and I discussed this yesterday. Unfortunately, she and I both were unable to find anything in the code or prior ordinances that say what the standards are today, meaning how you make your decision. So in light of this, we're requesting that the hearing today be to a date certain, perhaps next month, so that we can get some clarity on that. For the Board of Adjustment code regulation, the applicant is entitled to a continuance. So we are hoping that, right? Because we're just very concerned about whether we'll get process here, whether we'll get a fair hearing without knowing what the standards are, one way or the other.
Any comment? Chair, I just wanted to things. One, I wanted to I wanted to read the statement that he's talking about, which is in the nature of the request for appeal that you have. Also, I want to read the section concerning continuances, so that it's your decision to make. Because under the code, under section 3-34, subsection H4, it states that an application may be continued or postponed at the request of the applicant or the board by majority vote, but the public hearing shall be concluded within 60 days after the date of the first public hearing. So the applicant is requesting it, and it says may, so that means if you don't want to, I don't think that you have to under the code, especially since I received the email at 9 o'clock last night. We did discuss it beforehand. I've read the section on probable cause, and I think the burden is harder for the city for the town than it is for the applicant, so that I believe that he still gets his process, but the continuation is up to you. This is what it states in the application that he brought to my attention yesterday. The information provided, if you look at, it's the habit is page 2 in the appeal decision of administrative official application. On page 2 of the application, it states that the information provided shall be used by the Board of Adjustment in determining probable cause to believe the administrative official's decision in the matter described. The Board of Adjustment shall make an initial determination regarding probable cause. If a finding of no probable cause is determined, the hearing shall thereafter be adjourned, and the aggrieved party shall have a further right to file a petition for writ of certiorari with the circuit court in and for Palm Beach County, Florida. And what I think that means, and again, he's correct, you did not sign the term probable cause in your ordinances. I've spoken with the town manager and was not aware of this provision. It may be in a resolution someplace. So I am reluctant to say don't make that initial finding. But what that means is you have a situation here where the building official has made a finding. And if you think that did not have the authority or probable cause, which is a reasonable basis for making that finding, then you just say that up front, this ends. Which means that if the building official wanted to appeal your decision, you would have to take it to the court. But if you find that there was some probable cause, a reasonable basis for him denying, well, he didn't deny it, for not processing their application, then we should go forward. That is my interpretation. So in no way does that deprive applicants process. If anything, it would deprive the building process if he wanted to make that argument. I think it is. I think it should be, the code says an application may be continued or postponed at the request of the applicant. The applicant is requesting it. And it may be continued, but may is not shall. Does not say shall be continued. An application may be continued or postponed at the request of the applicant or the board by majority vote. So if you wanted to continue it, could, but only if there was an approval by a majority. So either way, it's happening.
I wanted to, this is Matt Scott for the applicant. I just want to object to that interpretation. That's sort of a interpretation by the town attorney. I think the way that the code is written, entitles my client to continue without a board majority. Because of the word or in the sentence. So the word may, if I could explain, I mean, this is getting very legal, very technical, right, if I'm being honest. The way it's written is, an application may be continued or postponed at the request of the applicant or the board by majority vote. If I needed a majority vote by the board to, there wouldn't be the word or in there. What this section, in my view, is saying is either the applicant can request it given it, or the board can by majority vote. I just want to get it clear on the record that that's not our interpretation of this code section, that it doesn't require you to agree to this. And I'd also just like to clarify that I'm not sure what the town attorney interpreted this weird part of your application. I'm not sure it says that. It speaks to the fact it's internally inconsistent. You have to see if there's probable cause to believe what the building official said. But if there's no probable cause, hearing shall be adjourned. And the aggrieved party shall have a further right to file a petition. So that doesn't even make sense. How would the building official sue my client for this town's refusal to process a permit?
The building official has the right to file.
An employee of the town would sue the town.
Not
based
employee,
on,
it's the position.
in any event, I think I'm making my point clear that that we don't even know what the rules are, and so it makes sense to defer this so that we can agree on the rules. That's a fundamental right of the American experience of due process, that we all know what were the rules of the game. And so I'm not even sure, with all due respect, I'm not in any way trying to be disrespectful, I don't even know how that works, that if you found no probable cause for the building official's decision and the hearing is adjourned, what happens then? Does the building official have to review my permit or hire an attorney to sue you? I don't even know the mechanics of that. I've never even experienced. I think what the purpose of this appeal is to give us an opportunity for you to weigh in on whether the building official's decision to process my client's permit was correct. We don't know that because it's not in the code. So this makes sense from a legal perspective, candidly, to protect the city and to protect my client's rights, for us to defer this until we sort this out. I apologize that I didn't raise it as an issue sooner, but we were genuinely confused. I think we can agree yesterday on what the rules are.
Right, and well, not on what the rules are, but this section should be in the code, and I don't know. I was willing to say, let's dispense with it and straight to the, I thought we had some agreement on that.
Yeah, and so
Throw this part out the window completely. Move to the substantive matter. That's what I think we should do. But I'm not hearing that you're agreeing to that
Correct.
anymore. You're not agreeing.
No, because then what would I be agreeing to? What would be your standard of review?
Standard of review is the same all the time. It's competent substantial evidence. That's what the appeal is about. To move to the substantive issue of the appeal. Whole probable cause section, we're willing to put that to the side. Working with the town manager, we're willing to put that to the side and go to the substantive matter, which is what we all thought we were gonna do before yesterday afternoon, when we started talking about this.
The concern I have with that is that we use competent evidence. So is it the city's, the town's burden to justify the decision, or is it mine? Vote is silent on that. Is it, if there's competent substantial evidence to support my appeal, are you bound to grant it? Vote is silent on that. And then we have this language about probable cause. Candidly, I'm saying it makes sense for us to see this hearing to another month or another time in 2 weeks, whatever the board decides. Understanding of what the requirements are for this hearing.
Point of clarification. So the operations of this committee would go back to town council for review?
I don't think so. I think this is a matter of, I think this is, I think this section probably be taken out. We can't find any basis for it, the probable cause section. We'll have to agree to dismiss that part because it may or may not be relevant. It would be easier if we would just agree to that, but I think that the attorney for the applicant is now raising other issues sure about, which I was unsure of now on the,
It's my understanding well, to the attorney, obviously, or with whatever their decision. It's not acceptable, then their alternative is appellate
correct.
hearing in the state of Florida.
That is correct.
Okay. But this committee is operating under these for many years.
That's what we understand. Many years, right. New here, the town manager, relatively new, appeals are very rare. So I don't know if you've had an opportunity, if anyone on the board has dealt with this issue and want to talk about the issue of probable. But there's nothing that we can find in the record for this language that's in the application. If we were to grant the continuance, I still say that it's up to you. We want to do it to a time certain on the record so that we wouldn't have to go back through posting or mailing. This will be to a time certain because the public is here, the public is on the phone. Everyone is taking time out to be here this morning. So if we do it, we don't want to have town have to pay extra expenses.
So that's why I wanted clarification on what would have to be done.
The only
Concerns that were
right. The only thing that he would work out the issue of the probable cause. That is certain. If he and I will talk about the standard of review is it's always been my experience. That's stated otherwise. It's competent evidence, and that's what you working well. So we can talk about that, and we may have to draw up something so that everybody is on the same page. But in my estimate, will be
Could I say something? This is Mary Ann Cody.
Go ahead, Mary Ann.
Based on what I've heard, I think it would be prudent at this time that the board entertain the motion for a continuance and call it to a vote.
So the request is for another.
Yes, sir. Yes, sir.
Clarify, you're making a motion. The
Yes.
application to board, regular meeting, which is third Wednesday.
Don't hear a motion.
I just want to,
Uh,
I just want to clarify, this is Jamie Gaffney, and I'm representing the building official. So just to clarify, motion would be postponed and then in that time, make a determination as to what the burden is and the definition of probable cause and how that's going to play out.
Correct. I understand.
Yes.
And I guess it would be implicit that it's done within the 2-month period that's required by the statute?
Yes.
Or should we, do we want to set a date certain?
Yes, I think the plan is to set a date certain to, is it November 18th? It will. It will be November 18th.
Okay.
At 8:30.
So would you like me to state it as a formal motion?
Please.
Okay.
Yes.
I move that we grant plaintiff the continuance he is requesting to review the probable cause issues at hand and reconvene on November 18th to have the new hearing.
All opposed, say nay. Nay. Motion fails. 0 to 5 votes. Go for-
Cody, did you vote as well? Cody, did you as well respond to, the motion?
I am not able to hear. Were they calling a vote?
Yes, they called the vote. I'll
Yeah.
go ahead and do a roll call. I'll go one by one.
All right, thank you.
Vice Chair Cody, how do you vote on the motion?
I'm in favor.
Chair Slow?
Yes.
Member Bingham? Member Hendon?
Yes.
And Member Joa?
Motion fails. 4 against.
Mr. Chair, for the record, do we want to deal with the issue of probable cause at all, or do we want?
Chair?
He has probable cause. Okay. Petitioning. You're not a certified building inspector, then they would be probable cause.
abundance of caution, I would like, if that is your position, I would like the board to make a motion, someone make a motion that there is probable cause. Let's vote on that so we can move on to the substantive.
All in favor of the motion, or roll call vote?
Member Bingham? Member Henry?
Yes.
Ms. Lo?
Yes.
Hello? Vice Chair Cody?
Yes.
This probable cause is a vote of 5-0 by board.
If I just might interject for a moment here, just because we want to make sure the record's very clear. The application says, the information provided shall be used by the Board of Adjustment in determining probable cause to believe the administrative official's decision in the matter described. If we clarify for the record, what is the probable cause to believe? Because what I heard was, let's use the building. Meaning, there's no way, there'd be no scenario not to believe him. So if you could clarify for the record what the probable cause is, so we can have it very clear. I believe the board's required to make findings that are the basis.
Okay, I'm gonna disagree with that. It says, first of all, the entire board has the packet. The board has reviewed the packet, chairperson spoke, other members are presumed to have read the packet and made a determination of probable cause. It does state the information provided shall be used by the Board of Adjustment probable cause to decision matter described. So the information is the packet that they've been given, and it is implicit that they have reviewed the material, they've made a decision on probable cause. We're not going to belabor that issue.
Well,
Again,
but just so we're clear, no one has said that they reviewed the packet. No one said that on the record, that it's implicit. Typically, what we hear is, I reviewed the materials, the information provided, the building official provided me X, Y, and Z. Based on that, we find probable cause. No one has said that they reviewed the packet. I'm not questioning whether you did, but typically that would be stated on the record for something like that. You would say, based on the information provided.
but we both agreed that was it.
Right. Listen, I'm trying to navigate it as well. It seems like there's a burden on the board with this probable cause.
Your due process, they've already made their decision, they've already voted. The due process, we're about to get your due process. As I stated previously, that section, if it's applicable at all, really goes to whether or not the building official has done his job. And they've made a decision that he has done his job to the point of reasonableness. And so you get to make your case at this point. As you stated before, even if they found that there was no probable cause, what occurs? It just adjourns, and it doesn't state that your building permit is processed or otherwise. So we are going to move on from this section. It's on the record. We're moving on from this section, moving to the section that deals with your application. And this board is prepared to give you complete process in your application. That's what we're going to do next. So your comments are on the record. Now let's move on.
Will be made once we hear testimony. And if you're implying we haven't read the packet, shame on you. Because you read everything. That's our responsibility, that's our job. When you get a court case, do you still file? Yes. Read them too. Please don't imply that we're derelict. Understand?
I wasn't implying that. Typically, there would be a stated basis for your decision. And so I was just saying that no one has said anything about that. Of course I wasn't implying that. Of course, I'm assuming you did. But we have a court reporter here, telling a decision typically, so that wasn't my implication, I apologize, that it came off that way. Wasn't my intent.
To speak on this item, please stand and raise your right hand. Swear you affirm the whole truth and nothing but the truth? Clearly for the record and whether or not you have been sworn in. And please directly into the microphone.
Yeah. Thank you. My name is Matthew Scott. I am an attorney at Dene Miskell and Backman with an address of 14 Southeast 4th Street, Boca Raton. I am here on behalf of applicant Waterfront IC7 Properties LLC. I have been sworn in. Again, just for the record, I want to clarify that I want to state that we do object to the board's refusal to consider the matter in light of us really not knowing what the rules there are. Having said that, we're going to proceed with our presentation. First and foremost, the agenda states that we're asserting that we should be allowed to obtain a permit. I want to clarify, again, if it was my mistake in my materials, not making this more clear. Actually, two components to our request. First part is we are appealing the building officials to process. That's the first primary part of our applicant. What my client is stating is, at a minimum, the building official was wrong, refused to even review the application and provide comments about how it was instituted. I stated that in my justification statement, but I apologize if I didn't make it more clear. The second part of our request is that the building official's decision was wrong. The basis for rejecting it was incorrect. Stated basis in the building official's letter provided to us was that his interpretation, a seawall, accessory structure, and you can't build an accessory structure without a principal. I just want to make that very clear before moving forward. Now, just for some background, I do believe most in this room are familiar with my client's property and some of the history here. But just to make it clear, my client owns a property in the town of Ocean Ridge and would like to construct a seawall on the property. A seawall is defined, it's not actually defined by your code. That's an important point. Nowhere in your code is a seawall defined. But there is sort of a common understanding of what a seawall is. Merriam-Webster's dictionary defines it as an embankment to protect the shore from erosion or to act as a breakwater. And so, of course, we're all familiar with seawalls. We see them in your town. They're on virtually every property. My client submitted a seawall permit application. Back up by Exhibit 1 after the deposition. My understanding that there was nothing insufficient technically about that permit application. The permit application fee was paid. General contractor signed the permit application. My client signed the permit application. And there were plans provided to construct a seawall. Now, the building official based on deposition testimony that we took earlier this week, reviewed the permit application and spoke with the town planner, and they exchanged some emails about this and issued a letter that is the basis of appeal, stating that the town was refusing to even process the permit. Right? This is a very irregular result, that they are just giving it back to us and they won't even review it or provide any comments about what the insufficiencies are. And the basis for this was his interpretation that a seawall is a type of accessory structure, and you can't have an accessory structure on a lot without a principal structure. As you may know, my client's property is currently unimproved. In order to do anything on the property, first step would be to install this wall. So we were shocked to receive 0 comments whatsoever. To tell you my experience as a land use and zoning attorney, typically you submit a permit application to any municipality that checks all the boxes, has all the requirements on it, and the application fee. The town, at minimum, reviews it and gives you written comments as to how it's insufficient, or offers to meet with you to explain what was incorrect. In this case, the building official took the odd approach of just saying, take it back, I won't even process it. So, what we see in your code when you review your code, starting with section 1.3 definition. Accessory building or structure is defined. It's a detached subordinate building or other structure, use of which is clearly incidental and related to that of the principal building or structure, and which is located on the same lot as the principal building or structure. So this definition, first and foremost, supports my client's argument because it states an accessory structure is a building or something that is used in relation to a principal structure. There is no way to use a seawall. A seawall is a fundamental component to constructing on land that is on waterways. It is similar to a foundation. And so the first thing that supports my client's argument is the fact that your own code doesn't include or contemplate a seawall as a type of accessory structure. Next, we go to the other parts of your code that talk about accessory structures. Section 64-41. Says all accessory uses, buildings, and structures shall be located on the same lot as the principal or main use and not within any required yard setbacks, except as provided in this code. The accessory use is subject to the same setback requirements as for a principal use. Now, as we all know, seawalls routinely are located on a property line and come up to the edges of property lines. So this is yet another example of how a seawall is not an accessory structure, because it routinely encroaches onto a setback, comes up to a property line. It is not like a pool or an detached garage that must comply with a 20-foot setback or be set back from the property a certain amount. And during the deposition testimony of the building official from Monday, we asked very clearly, does the code say a seawall is an accessory structure? And the answer was no. Then we asked, how did this decision get reached? The building official said, well, I did some research and talked with the town planner. We don't know what the town planner said. We don't know why the town planner didn't give written comments. They just said, this is the interpretation we made. Well, then we asked, okay, well, are there places in the town? Did you look at precedent? How the town handles this sort of thing? No, we didn't look at that. I asked the building official if he's aware that there are places in the town where the property is unimproved except for a seawall. He said, I didn't do that. I didn't look at that at all. If there's a seawall there, it should be teared down. So, this time, I have some copies that I'd be happy to share. We'll call this Exhibit 2. Here, I'll take it up. Do you want the exhibits or do you want the court orders?
I don't know.
Got it, okay. No, I'm just not sure how you want it. Okay, so do you want to see these first, Jamie?
Yep.
Let me just show them.
Give an extra copy or?
One for you. Here's,
They're the same. I can keep one?
yeah, you can keep one of each.
Oh, they're different properties, got it.
One.
that will also be.
Oh, great. Okay, so then I'll just wait for that, if that's okay.
Yeah.
Awesome.
Just be clear, is this a composite exhibit?
Sure. Okay.
No. Jones.
Okay.
I'm sorry.
I'll go one by one.
Thank you very much. Okay, so before going into that, it just came to my attention. Owens Foster, the law firm counsel for Legal Works, has represented my client in another capacity. I wanted to get that on the record. I don't know if that's an issue.
Well, I'm not aware of that. We've worked on conflict checks and we're not.
Thank you. Okay, back to these exhibits. And I'll explain what we're looking at here. The first one is a property in the town of Ocean Ridge owned by Ilona Gordecki, Brizard Gordecki. Sorry. Okay, we'll scroll through them. The point is the same, though, that each of these exhibits show a vacant lot with a seawall. Clearly the white line, obviously a seawall. And the county property appraiser, the Palm Beach County property appraiser states clearly in the use type that these are vacant lots. So what this shows is two things really. One is that the building official's interpretation is inconsistent with the reality in the town of Ocean Ridge, and is inconsistent with how the county approaches properties that don't have a principal structure. They classify them as vacant. So in discussions in the deposition of the building official, we asked about these properties, about these various properties in the town that have seawalls only. How did this happen? Now the building official said, I have no idea. I didn't look at them. I don't know. Maybe there was a house on them and it was demolished. We said, well, would it be allowed to keep its seawall? The building official said, no. They have to be demolished. Seawall has to be removed if you demolish a structure. So we don't know how these became vacant, but we know that there are properties in the town that have seawalls only. We know that the town official, building official, who's in charge of code enforcement, is doing nothing about it. He's not asking them to remove those seawalls. Now, of course, we all know that would be a nonsensical thing to ask. You want property owners to maintain seawalls, to protect upland areas, to avoid soil erosion, to avoid flooding type issues, sea level rise. And so these things are existing in the town, and the town's doing nothing about it because seawalls are not accessory structures. They do not need to be removed. In common practice throughout South Florida is that a seawall is more of a protection for a property than it is a use type on a property supporting the principal structure. And so it was very troubling to me.
Sorry, I'm just gonna make a suggestion. Has deposition been introduced to the record? I didn't get what was referencing the deposition. You keep referencing that we have no testimony. On a guy, you're making representations, that haven't been. Sorry. I was just saying that I don't think that the deposition of has been introduced. There's no testimony from Durrani Guy. He's summarizing statements outside of this hearing. So I'm going to suggestions references prior deposition.
What we see in the images that I'm showing are that clearly the town, multiple properties with walls only. The building official has refused to even process my client's permit and explain why there can be these other properties that have seawalls without a principal structure. My client cannot even get comments on his seawall permit. With that said, I'd like to call Mr. Durrani Guy as a witness to ask him.
Well, I think it's better to let him get his case out, write your questions down, and we'll absolutely be given an opportunity to ask both sides questions.
Yes, good morning, everybody. My name is Durrani Guy, building official, town of Ocean Ridge, 6 Clark.
Thank you. Guy, what was the basis for refusing permit?
It was determined that application lacked vital evidence of an existing structure on the parcel or a proposal that has been by a development standard review process for an improvement property, and not having this associated vital information permit not be processed.
And did you check to see if that is practiced now based on prior examples?
I did not. At the code regards how an accessory or structure, based on my interpretation from or ordinances that talks about accessory use, that means that are customarily incidental to the primary use area of common use, expected that it cannot be, suppose that this code is intended to prevent it. Accessory is, but not limited to garage, parking, porch, docks, etc., unless otherwise provided, shall be located on the same premises as the principal use. And I'm quoting from Ordinance 1.3 on the definition. So I have this actually justifies that a wall application would be considered an accessory structure under that definition, and as such, does require principal, proposal or a funded parcel.
Just to clarify, it's your interpretation that a seawall is an accessory.
Both an accessory and
So, are there currently code violations for properties I put up that have seawalls without?
my role as, code officer now, most of my, notices are based on complaints from residents of a property. I do not arbitrarily drive around town and cite properties that are existing. Some way. Answer that I have not.
What you see on the screen, would that appear to be not permitted by the code?
But I see a lot with a white line. I have not investigated. I don't know what it is. Type of structure, how it is that way. I cannot. That I have not.
So after this hearing, are you going to investigate obvious violations?
Objection.
If a resident does comment, I will property, but I will.
Okay. How many seawall permits have you reviewed on it?
I have done a few on the 10,
The town specifically, or in your career?
both in my career and in.
So how many specifically in the town?
I have not done the research to see exactly what I meant at that moment.
So you've reviewed in your career less than 10 seawall permits.
I'm not.
Reviewed less than 10 seawall permits.
I have.
Consult with and make a decision. Process compliance.
My basis was primarily based on ordinances. I did consult for report. Validate also the attributes of the code that I had not known that would actually. Also, that was primarily for time at the document. At the time when
Did you consult with an attorney on this application?
there was no initial consult, however, when I did draft the letter, branch,
Did Mr. Let's give written comments back or verbal?
it was verbal and was drafted.
In your short time at the town, I was told you've been at the town maybe months. Have you issued any other rejection letters, process letters?
I have not.
Prior to coming to the town, had you ever processed?
I don't recall if
Did anyone assist drafting the process?
yes, I had a my let's see,
Gorman here? Mr. Guy, so if a property has a seawall without a principal structure, someone calls in your position, they would have to tear down the seawall?
The answer is yes. They can not have that would violate. So then, would it be your position that if a demolition permit is issued for a house on a waterway property, in order to close out demolition, section would also have to seawall was removed? Yes.
Thank you. If I could just ask a few questions. Oh, all right, fine. Thanks, Mr. O'Gorman. Can you share with us your contribution, your process you went through in getting the Guy permit section letter?
Yes, sir. I'll be property.
Does, you being the town planner, can you tell us whether the code states a seawall is an accessory?
Accessory. Finding it.
Code does not identify a seawall as an accessory. Correct. Decision to, does it matter? Consult with anyone other than Mr. Guy prior to giving Mr. Guy your opinion on. But yeah, I apologize. I should have asked. So, provide your address and employer for the record. How long have you worked there?
Can you directly,
700 Highway 1.
How long have you been working, I guess, on assignment from your company to the town of Oaktree?
Approximately.
And your experience, how many permits have you just processed? How many seawall permits do you recall processing or reviewing? Excuse me? Find any questions?
grab the mic and say really, it's hard to speak when you virtually.
Yeah, so just a last question. You agree with what Mr. Guy said relative to the house is demolished, the wall should be,
Yes.
and can you recall how many demolition part of review? I'm not sure if plans would review those, but to the extent, do demolition permits for the town?
I don't think I've ever. That's what I reviewed.
Thank you. So Jamie, maybe I'll look at my part and then if you
Yeah, no, that makes sense to me. If you want to close up yours, then I'll give my presentation.
Right. It's quasi-judicial. So-
Yeah, it's flexible. I'm fine with that.
Thank you, sir.
Say you're
Did
done?
you say you were done?
So I'm just gonna make a few comments, and I'll reserve, just an opportunity to rebuttal. So, thank you very much for bearing with me. I think that from my client's perspective, it's very clear that this was a sort of unique, one-time refusal to process. What we heard from Mr. Guy and Mr. Gorman is that this interpretation of a seawall as an accessory use forces the town into this crazy position that any time a house is demolished, the seawall should be removed, right? Which would endanger neighboring properties, would potentially create flooding issues and soil erosion. And so that sort of illogical result only strengthens my client's argument that this is not an accessory structure, it is not an accessory use, because it creates these untenable situations that the town, no city would ever want, just removal of seawalls. The fact that there are multiple properties in the town that have seawalls with no properties, that no one's doing anything about, also supports my client's argument that it's not an accessory structure or an accessory. Another point that really drives home why my client should at least receive comment on their permit application, a denial notice saying why it's being denied, is that your code doesn't even include seawall as a type of accessory structure. And so the code, the building official said, well, it's an accessory use, which doesn't even make sense. How could a embankment be a use? So in light of that, at a minimum, we would request that the board find that there was no competent substantial evidence for the building official's decision to refuse the process. At a minimum, the board should direct the building official to process our building permit application. It's another great example of how sort of nonsensical this result is, how it's sort of directed at my client directly as opposed to a town policy, is there's riprap that you routinely see in waterways to protect upland areas. And so it's applicant's position that the building official's decision, no competence, that it's irrational and that it's been unfairly imposed on my client. I'd just like to reserve just a couple of minutes to respond or rebut anything that building official. Thank you.
Good morning. My name is Jamie Gavigan. I'm at Jones Foster, PA. Address is 505 South Flagler, West Palm Beach, or Suite 1100 West Palm Beach, and I represent the town building official in the town hearing. And just be clear, and I think Mr. Scott made that clear, but the scope of this appeal, whether or not the town official was correct in not processing the permit. That's the scope of this appeal, not anything further than processing the permit, addressing whether it should be granted or denied. It's simply process. I just wanted to make that clear for everyone that that's what's in here. And their appeal, the packet, Waterfront makes clear that they intend, and they state in their application, the applicant intends to construct dwellings on the property. And it says that in order to construct the dwellings, they have not presented any land development plan showing what dwellings they're going to plan to construct. They haven't indicated whether or not they plan to subdivide the property. They've provided a site plan.
Are you able to hear me clearly?
Yes, thank you.
And to just speak a little bit closer.
Sure. Is that better? Everyone hear me?
Yes, thank you.
And Mr. Scott in his presentation also stressed a number of times that seawall is not explicitly defined as an accessory use in the code. I just wanted to make clear. There's nothing in the code that says that accessory use is not limited to accessory use. Can you hear me? So I just want to make that clear as well. And with that said, and I won't belabor the point, but I would like to, I'll first call Ronnie Guy, town building official, ask him a question. Mr. Guy, I believe you may have mentioned this in your initial testimony, but what's your position with the town?
Town's building official.
And you've been the building official for how long?
Since I first.
And before that, what was your, where were you employed?
I was employed at the time it was at the town. Sorry, at the
Three? Sure. Mr. Guy, when you typically, when you receive, or the town receives a permit application, comes to you, take me through what you typically, how you typically permit application.
once a application document package and make that there's copies document and based on type of document that would once that and work I also ask applicant item by of
And this situation, receive waterfront ICW application for a sequel permit through how you handle that application.
so of the size and document and large application that would actually have documents have by the and the process. So if a company define the structure and also development plan and they're turning that have documents that was that document. I asked, I went back to my office and looked at what was and that the parcel must have type of land development reference and, ordinance regards to having structure on the property, but I came back with, to ask if there's something that we thought was applicable after that. Back to, applicant that we process.
So just to kind of summarize and follow up, received it, you look to see if permit application, permit, look to see existing structure or an improved land development plan or proposed, property, correct? And determined that there was neither existing principal use or a proposed property, correct?
That's correct.
And once you made that determination and used the code, determine if if the foreseeable accessory structure.
Yes, I did, I what, that's back and find that.
And you looked at sections 1-3 and section 4-41 of the code. Evaluate your opinion. What was it? Structure.
Well, I did extensive, but
And then you reached out to the town land planner. Permitting. I'm gonna, I only have one copy, it's part of the application. So, I want to introduce essentially the letter from Mr. Guy, as Exhibit 5, or, not process the permit, accessory, and so it's your opinion as a town building official that the proposed seawall is an accessory use for the code, not have a permit for accessory process without proposed. And you know, and, so that, and in fact, and based on that determination, sent that letter, Waterfront ICW, in this process. That was in, right? Never made a substance determination. Evaluate. Sure. So you couldn't process it. You never processed it, so you never got to the second substance analysis. Whether a permit.
that is good.
I think Mr. Scott indicated a hypothetical, and if there was a building a ranch style home on a waterfront and it was torn down, that I guess the question would, that structure was demolished to require, and there was, right, if that structure was demolished, after it was demolished, there exists well indoor dock, fire property owner, would that be a violation?
Once we, application, if there's, and
I have no further questions. I'll also call some questions of, Mr. Borman. Mr. Borman, you mentioned previously, you're obviously the town, correct? How long have you been acting as the land planner now? Approximately. I'm going to, for the record, I'm going to this is Exhibit 5. This is Mr. Borman's CV. Record. Mr. Borman, Mr. Guy mentioned that he reached out. Is it correct if he reached out to you as analyzing permit application, correct? And what did Guy ask you? Regulations? And reached the sorry? So your that seawall would be accessory use town code. And your opinion on your analysis code and your that pursuant to town code, there cannot be not process accessory without a principal place or code. And there's nothing. Is there anything in the code that requires that all accessory uses are created in code? In fact, for the definition of accessory, I'll read it under section 1.3 under definition accessory use. Accessory use is not limited to garages, parking, boats, docks, swimming pools, etc. shall be premises. Correct? Under that, that fitted, limited to accessory uses that are not listed under the. What is currently property currently submerged? And there's clearly no buildings. I have no further questions for you. I'll wrap up briefly since it's already been going on for quite some time. Based on the testimony you've heard today, it's clear that this current property, which is submerged land, there is no principal structure on the property. There is no approved. There's been no proposed land development plan, but property will what the applicant proposes to construct on the property. There is no property. The applicant just indicated in his skills that he intends to construct dwellings on the property, and there hasn't been no application as to whether they were subdivided. There's been no application that provided any proposed special site plan for the property. Never proposed showing that there would be how drainage would work, where the roads would be, any of the above, and that's all necessary under the testimony from the building official and the land planner that was a requirement in order to issue or process a permit for an accessory structure. That's what you heard here. Building official and the land planner in their analysis of the town code have made determination. Accessory, rental, and primary use there is not on the property. Their testimony is that they could not, because there was applications for accessory use or structure that a principal use, they could not even process the permit. That is the determination for this board. Okay. That said, I'm going to just, again, these guys just introduce for the record sections referenced today, section 1.3 and chapter 63 and 60 code as positive exhibit 6. So I'll end my presentation. Thank you very much for your.
To just respond. Yes, sir. Sorry. First, I just have one more exhibit. Mr. Guy, if I could just ask one or two more questions. Reach out to my client or his contractor at all to discuss the your procedure.
I did not, on the advisement from attorney branch, but
Never spoke with my client at all about how they might correct. Did my client reach out to you?
email from I did advisement. Forward those.
A letter that I'm going to provide a bit. Scan it in. I'll talk about it briefly as I close it. The letter that I'm sharing right now is from another entity related from my client, putting the town on notice of these seawalls setback violations, January 2020. Saying, I'm a property owner in the town. I'd like you to do something about these violations. The guy stated on the record they've done nothing about it unless he gets a call. So the town is aware, you're going to see the letter in a moment, the town is aware of some of these issues, is doing nothing about it. So in closing, the applicant believes that he should require the building official to at minimum process the permit application, provide my client with comments relative to the issues. Because first and foremost, it's been the practice of the town for years and years to allow seawalls without a principal and not demolish them, right? Of course, because you wouldn't want to have soil erosion and lots just falling off into the intercoastal. You'd want the seawall to stay there. So it's been the practice of the town. Second reason is there is nowhere in the code that says this seawall is an accessory use. It strains logic how a wall could be a use. And there's nowhere in the code where it says the seawall is a structure, is an accessory structure. Another reason why we believe that the building official's decision is wrong is that this is not the practice in the vast majority of municipalities. They routinely allow standalone seawall permits. Because you want to encourage people to protect their property, irrespective of whether they're going to build a house on it or the timing of that. It benefits an entire town to have people protecting properties that are either submerged or on the waterway. And then finally, perhaps the most important reason why, yes, one of the most important reasons why the board sort of reject building official once upon a time decision. The town has never done this before. Building official and the town planner said they've never just rejected a permit. It isn't what they normally do. They couldn't give an example of this. So it appears that they're not treating my client fairly, which is something that your code specifically requires. And so what I'm showing now on the exhibit that I just was talking about briefly to close is from McCormick Mile Investments LLC, and there are attachments to specifically identify these properties and talk about how they're illegal. The code shouldn't be allowed per your code. Please do something about it, and the town is doing something about it.
I'm going to object. This is for an entity that applicant. There's no evidence that the applicant said here that their permits are and the members in here was proper, is valid. Entirely just separate and unrelated issue that's not before, has no relevance during and didn't even pursue. And it's not even.
What the letter does show, while it's from a different technical ownership entity, it shows that the town is on notice of properties with walls with nothing on them, and isn't doing anything about it because it's not the practice of the town to not allow people to have a property with. So they're singling my client out and comment. There's evidence of that, irrespective of which entity provided the letter. And it makes sense that perhaps they're not chasing these down per se, because they want to encourage people to have seawalls on the property. With that said, I'm happy to answer any questions you have, but I would respectfully request that this board require the building official at minimum.
And just be clear, I just want to make one further suggestion. There's nothing in this letter as I'm looking at it now, and this wasn't provided. Anyway, that's provided right here. That there's properties with seawalls without principal structures or proposed principal structures in place. That was the representation I just made. There's nothing in this letter or attachments show evidence that there are walls without a principal structure. And again, this is a completely unrelated issue that has no bearing to this.
So are you asking that the board not accept it as an exhibit or consider it?
I would just point out to the board that there's no reason to consider this letter. There's no reason to consider this as evidence making your determination as to the appeal.
Relevant agenda item, yes or no?
Yes, it's relevant. Why? Because town provided specific examples of properties. If they're doing anything about it, they know we've never been, no one's ever complained, no one's ever sent a letter. Here's a letter talking about encroachment, talking about docks outside of property lines. So I think it's relevant, but especially in a quasi-judicial setting, right, where we're not using strict evidence code here. Rather, the point remains, there are properties in the town with seawalls with nothing on them. The town is not tearing them down or requiring them to be torn down. Thus, it stands to reason my client seeking a permit for a seawall alone is conscionable in the town because it exists currently in numerous places. This letter supports that, but we don't go down this rabbit hole of ability. Because the larger point is fairly obvious.
Maybe in my mind, there weren't, when, in the development of Ocean Ridge, there wasn't necessarily submerged lands, sold the rights to certain lots that were not already. From my understanding, that developed, Bill was using islands bordered and identified, Harbor Island. There must have been seawalls constructed prior to the initial selling of that land. Didn't sell land and then individuals come and build seawalls for those properties. That would be my understanding. I find it part of water. So the existing lots with walls was initially established as part of. Those properties, the overall. That's my knowledge. Talking about the. Oh, when they built the island. The name on actually, waterfront IW property.
It's that, sir, you are correct, the letter is not from Waterfront ICW.
Therefore, I don't think it's relevant to this single item in.
Will not, if, the board doesn't think it's relevant, you will not consider it. Not at this point, I think you're at the point of public comment. Appropriate point,
Board will have a chance to answer. At this time, any other member of the public who wishes to get relevant information in this one agenda item. Forward. Anyone? Contractor? Applicant? Okay.
Thank you very much for being accommodating. Obviously, there's some murkiness here on what the process is, which I still have concerns about. And putting that aside, I think the question about how the town was developed to support my argument here. The town itself was once submerged and constructed by creating seawalls and buildable lots. My client is seeking subdivision property, plans to develop it. But in order to get to that step, the person needs to get a seawall to protect the property and establish space for their property. So what we've heard here today is that, one, the code does not say well is structure, that it was a interpretation by the building official, town planner, not based on precedent in town, not based on other cities, just based on their interpretation. And interpretation clearly flies in various places in town. perhaps most importantly, it is sort of shocking that for both the town planner and the building official, this is the first time they've just flatly refused to give comment. Our request, very modest here. We're asking at a starting point just to receive comments and feedback relative to why it can't be. I thank you for your indulgence and allowing us this time.
I'll leave it, for the testimony today. Principal use on the property, so proposed building planner, termination, code, project permit, accessory, out, and on the FCC card, building.
Fine, members of the board have.
Amy Gavigan. Sure, and I think that the applicant, Scott would agree. The scope of this you're considering today is whether or not town building official sent a letter not process the permit for a C. The process permit go to the next. The issue for this appeal is whether or not that determination as to process was correct. If there was substantial competent evidence, not process the permit without principally existing. And so the determination is whether or not it should be processed. We don't address whether it should ultimate outcome of the permit, whether it should be granted or denied. It's strictly should the permit processing. That's the issue from the purpose of the town and the town building official. Scope of whether or not the application should be processed. All right. Process meaning that the town would need to process it and then go to the next steps in evaluating whether or not grant or deny and further the analysis as to how to handle the whether or not the deny. The building official got to the step where reviewed the permit application, decision that it was accessory use without a principal use in place, could not, on that basis, he couldn't go any further. I can't process it based on my interpretation of the town code. And he never went to the next phase of analysis. We haven't even got there. He's getting cart before the horse. Right here, we're just making a determination hearing today as to whether or not building official is correct. Could not process the permit.
You said the purpose of the seawall, paraphrasing, going to erode section of property. What evidence that's property?
Yes, so the definition alone of a seawall is an embankment, soil erosion. That's what a seawall does. That's the first thing. Okay? And the second thing is, as stated on the record, my client's property is, we all know, similar to how the town was developed, way to protect property being submerged. That is what is done. Build a seawall and fill. right? All of the intercoastal, the barrier islands up and down the state were constructed in this way, right? They were constructed by the Army Corps of Engineers years and years ago by bringing in fill, and which the town planner stated, and building seawalls. So that's just a fundamental of waterway land development. Put an embankment such as a seawall up, or riprap, the water from entering onto the property during high tide times or storms.
Now, wasn't it accompanied by a detailed plan built on that property? And I didn't hear any.
Well, I think, sir, I don't think that Jamie said that the barrier island of Ocean Ridge, when it was being bought, had homes, building plans. I don't think Jamie said that, right? Know that.
I don't know personally, and that's not a question for me. It's how the, I would be guessing it would be my place, but I would say that when you talk to development, there's a plat, have a planned development. And that everything has to be, I think that's really a question for the town planner.
That was my part of it. Partial.
Correct. There,
Right, and so what we were looking for was that to be provided to us with comments in response to the permit. But what we said was, the door shut in our face, we won't even do it. We won't circulate it to the town planner for his comment. Circulate it to a structural engineer that perhaps the town has on staff. The normal process for a building permit wasn't followed here. That's our point.
Vacant. Obviously, some structure on it. Assurance that the owners of that vacant land will never sell it to build, or will never build themselves, therefore, construction. But any evidence, never build on that. Rebuild on it.
Excuse me, what property was
The pictures, so,
the 3 lots?
see all around property that at one time, they had a structure. What if I own that piece of property? I'm gonna sell that property.
I honestly not how that what happened is one came and had a demolition permit. I'm going to, as a part of that demolition plan, a requirement that all accessories, fences, any court have to be as a part of that application. Is an approved application build and allows of funds once that approved here. They could actually have the land vacant for a while and then a requirement that
Say this, so that, I wanna make sure that the board is focused. I have not evidence. I don't know what the circumstance was, don't know how long the walls have been there, don't know if the code changed since then, don't know anything. And I was waiting for the applicant get that evidence, none was presented, so you would not be appropriate for you to guess as to how those lots came into it. That is not the purpose of this. It's relevant that they brought it up, but it's not the focus of this. So unless you have information that goes directly to how they have seawalls, you should not really consider that your discussion on this particular issue is in place right now. I want to make sure, I want to help you stay focused. That is correct.
Clarify for the record, we're moving back to accept seven into the record. And that was motion ready and by Kelly. Member Bingham, vote. Member Joa, how do you vote? Oh, yeah.
And just to be clear, I mean, I'm not sure. I was objecting, I want to make clear that I consider that it's not relevant to consider in making your determination. Whether or not you make it part of the record or not, I just want to, that from the town building announcement, shouldn't be considered in making the final decision for the appeal.
Right, I mean, it's automatically.
Yeah, it's part of, for the record. So I just want to make sure it's part of the record, but the town, in our opinion, shouldn't consider it.
Here's how do you vote on that motion? The motion on the floor proposed by Mr. Bingham was to not accept Exhibit 7, as Exhibit 7. Yeah. It would still be a part of the record, right, it would still be a part of the record, it just would not be exhibited.
Not considering. Basically, will not be considered.
Agree.
Member Hendon.
Yes. I now declare the official hearing closed without motion. Clarify the motion.
And I will, and you should deliberate, and in making your motion, it should be, have some facts to support your motion. Why are you making, you want to discuss it a little bit, and then the maker of the motion could say, I move to X, Y, Z because based upon the evidence, based upon what's in the record, and based upon what I've heard, the testimony, I believe X, Y, and Z. Whatever your motion. Certainly discuss it more.
Well, I could say, based upon what I've heard, it's relevant. Stand by official. Although, I think the applicant should receive appropriate comment from why his permit, if they're due that. But that he received no comment whatsoever. Any correspondence?
The rejection letter.
Rejection.
Right, they didn't process and provide comments. Different. There's to accept it, give a letter as to why you want to accept it, and processing it, and issuing a denial. That's.
And just to be clear, I don't think there was ever denial of the permit. refusal to process the permit. Making the distinction, there was never a denial of the permit. Final decision, I guess, for purposes of the application process.
So I think an applicant does deserve appropriate comment from the appropriate agency why that action process is not followed.
I don't know if we have exhibit B, just so we're clear on what we're talking about. Exhibit B, the letter discusses sections of the code. Sections of the code, oh, okay, great. I'll put it up. That are relevant to the decision. And then it states in one paragraph, based on the above and because there is no principle existing or proposed on the parcel, and that the town code does not permit accessory without a permit for the seawall cannot be processed, the permit application will be voided. So those are the reasons given. Are you saying they?
No, this is exactly what I'm saying, but the attorney claimed it was never received.
No, I'm sorry, this could be confusing. Not what I didn't say I never received the letter. What I said was that we're requesting the town agree to process and provide comments in the ordinary course for what they do for every other building permit application, for my client's building permit. What they said they did was, they gave a letter as to why they won't even process it, something they said they've never done before in the town.
Okay.
So we're saying just give us the normal process.
Let me try to give an analogy. That's based upon what heard from from the building official. If you look at the definition of accessory, let's say that the applicant in the building official's mind, correct me if I'm wrong, the applicant, the town, has to build a swimming pool. That is under accessory use. This is a hypothetical situation. Has to build a swimming pool. They gave specs for the swimming pool on a vacant piece of property. The building official, instead of processing it and saying, okay, this is a great pool, is perfect, it's a good size, it's deep enough, but it doesn't have thin around the edges. The building official, in that case, would have sent it back, said, where is the rest of your application? Where is the house? Where is the structure that goes with it? That's kind of what we're dealing with. The applicant is saying, don't think about principal structure. That's not your worry. Give us some comments on, and if you're not going to give us comments, deny the application. Instead, building official, send it back. Basically, it's incomplete. So that's really the issue. And correct me if I'm wrong. The issue is whether or not the building official was correct in not processing it versus denying it or actually reviewing it substantively, giving comments on the quote-unquote pool, if I have to say. In this case, the fee. That's how I broke it. That's your task. There's been no motion.
Would you like a motion? Are we still discussing?
I think they're ready for a motion.
Okay.
All right. How about, based upon the testimony given today at today's hearing from both the building inspector and the town planner, we move that the building official was correct in not issuing the permit.
Processing.
Excuse me, processing. I'm sorry.
The motion on the floor is that building official was correct in not processing the permit. The motion was by Vice Chair Cody. Vice Chair Cody, how do you vote on that motion?
I vote in favor.
It was seconded by Member Bingham. Member Bingham, how do you vote on that motion? Chair Sloat? Member Hinton?
Approved.
Member Joa?
Motion carries 5-0. I now declare this meeting over. Thank you all for
Thank you.